Good morning. Welcome to the Light on Suitability podcast. I'm your host, Elizabeth Comeau. I'm with my wonderful co-hosts, Joe Haytas, author of 36 Strategies to Suitability. That's what we're talking about and been talking about for the past year. And Dean, he is the founder, operator, you correct me, of Lighthouse 9 Consulting, and he is an amazing guy. I think he's got a PhD. Is that right? And
Still working on it, but not quite there.
still working on it. It's about to get a
Yeah.
PhD,
Yeah,
which is the
start working
equivalent
on
of
my
a JD.
dissertation. Yeah. I'll start working on my dissertation in probably 16 weeks.
What is your dissertation going to be on?
Well, I have gone up and down as to what I wanted to study, and I thought I have made a decision. I think it's going to be very controversial, but I wanted to do something on the equality between people who commit murder, home invasion, whatever kind of offense, as opposed to those who commit a sexual related offense. The equality, the difference in parole. And what I would like to do is, once I complete that, make the dissertation, publish it, and then make it available to family members and people who are incarcerated, so that they can get a better understanding of what parole is like. And that, what a lot of, I think it's just good to educate the public on the differences, and, why is it so drastically different? For a lot of guys who have committed sex offenses, it's like, they're punished for the rest of their lives. And, where somebody can go out and commit murder and they're done within a year, they could be off parole. So, there's just a huge inequality in parole conditions, the things that a person has to go through. So I wanted to bring those things to light. And I figured that, doing a dissertation on it would be a good way to do it.
And I think adding to it, well, if you feel like maybe there's too much content already, but beforehand, the grant rates are obviously lower, and it's so much more difficult to explain insight. It's harder to get access to programming. Well, we know why it's hard to get access to programming, and I understand that because of the prison climate. But also, before we get started on the chapter, why don't you tell the audience also about Lighthouse 9 Consulting and all of the various trainings that you provide?
Yeah, we have 4 different correspondence curriculum that we offer. One is called Pathways, which is specific to sex offense related crimes. The other is North Star, which covers all other crimes. We have an advanced insight program called the Navigator, which usually people will go through Pathways and North Star and then into the Navigator. And then we also have a domestic violence course that we offer. Our staff are all clinicians. We're all certified and credentialed in the respective areas. So somebody takes a DV class, they have a DV instructor who's going to, provide feedback on their assignments, critique them, and grade their papers. We also currently go into Pleasant Valley State Prison in person. So we're running programs in there, which has worked out. It's just, we love it. It's great to go in and meet the guys and actually to do the work in person. And then we have a special suite of services that we offer where for 6 months, we'll have somebody call us once a week for 45-minute sessions. We help them in board preparation. And with that, we put them through all of our programs. It's a bit more pricier of a program. We put them through all of our programs that apply to them. So maybe it's Pathways, the Navigator, maybe domestic violence. We also do transcript reviews, CRA reviews, so that we can help them better prepare for the board. We'll do mock hearings over the phone. And so far with that program, we have an 88% success rate at the board.
So amazing.
It
sounds amazing.
We're doing well. And it's, we've had guys that go in on their initial hearing, a number, regardless to crime, it doesn't matter what it is, and on their initial hearings being found suitable. And I think that a lot of guys just don't know how to prepare. They don't know how to answer questions. They don't know what they're actually being asked. The difference between a credibility question and an internal question. What's your greatest accomplishment since you've been incarcerated? That's an internal question. It's not something that you've completed. Got my AA, got my GED. It's not that. It's internal. What have your greatest accomplishment for yourself? Because the board's biggest concern is that if we release you, are you going to reoffend? So your greatest accomplishment needs to be something that shows you're not going to reoffend. So there's a lot of work that we do with the guys, helping them prepare for the board. Currently, we're in every correspondence, every prison in California. We're also in 18 states across the country in the federal system. So,
Wow.
and it's really interesting because the constant theme that we see is that just about every state lacks programs for people who have sex-related crimes. And so, we get guys coming to us, and we help them out the best we can.
Yeah, I think it's amazing, amazing. I think
Yeah,
what
that's
would
fantastic.
be really
Yeah.
great is, I'm not telling you how to run your business. This was just an idea I had.
Uh-huh.
Offer that a year before their hearing, the 6-month program, and then they get their state appointed counsel who just does the refinements up till board. But I don't know if that would affect the grant rate or not. But
Yeah, well, it's usually up to them and when they get in touch with us.
I see.
For that specific program. Now, I've had guys get in touch with us a couple years before, and their family members, because it is a pricey program, they'll ask, well, is this too soon? No, because the more that they learn, they incorporate into their lifestyle, they start living this. It's a transformation process. And the longer they're living it, the better. And when they go to the board and the board's asking questions, all you're doing is talking about how you're living now. And it makes it that much simpler to answer the questions. Coping skills, what are you doing now? How do you view things? What is the mental process? What's going on inside your head before you apply a coping skill? So there's a number of things that we approach, and it's a lifestyle change. And when they go to the board, it's just that much easier for them to answer the questions. And so I think that's a big part of where the success comes. And of course, we've had guys who, I'm going to the board in 4 months, and it's like, well, we can see what we can do, and we'll work with them the best we can. But I had one guy whose attorney told him, she had worked with him for 2 years, and then told him, you need to postpone it. You're not going to be found suitable. And it just devastated him. And so he got a hold of me, and I said, well, when do you go to the board? He said, a month and a half. I said, then we got a month and a half to grind away. So month and a half, we put in the work every week. And when he went to the board, he's found suitable. Gave him a date.
Yeah.
And so, his attorney was shocked.
She wasn't incorrect, though, because without that work, she was saying, obviously can't do that magical thing in 4 months. You need this intensive workup. So, and that's kind of what we encounter as state appointed lawyers as well. It's just, I can't counsel 80 people like that.
Yeah, I was just happy to see the change in him and just to grasp some of the concepts and to really be able to articulate, his experience, his change, his background and everything. And then when he went, his attorney had told him, well, you brought your A game, and it's just, yeah, he did. And, ultimately you can take the horse to the water, but you can't make him drink. All we can do is provide them with the knowledge that we have, lead them to discovery, show them something different. But when they go to the board, it's up to them to deliver, so you can only do so much. Yeah.
I know. My clients always used to ask me, what are you going to do for me at the hearing? I'm like, hopefully nothing.
Yeah.
Hopefully I'm just going to sit there and keep my mouth shut until the end and say a few nice things about you. And some people get it, some people don't.
Right.
Wonderful. Today we're on Joe's book. This is the second edition of his book, and he's working on a third, but the second edition is what we're doing. Strategy 33, understanding the role of the district attorney at a parole hearing. I get the role of the district attorney at the parole hearing, make sure to protect the public. They represent the public. They're there to, stand in for the public and give comments about whether or not, and their opinions about whether or not the person is suitable or unsuitable. I don't think, there are certain district attorneys that are not as affable, I don't know what the word is, as others, but you will every now and then have a very, very ethically minded prosecutor who will actually come in and say, if a person's suitable, he's suitable, we have no objection. I've had that happen twice, maybe, and I've had a few submissions, where they didn't have much to say, we submit. But lately, I haven't seen that. I haven't had that as much. I think it's just kind of the luck of the draw sometimes. but usually they go in and object, and that's just their office policy. There was a time frame, 2 to 3 years, where the LA district attorney had a policy of not appearing. I think it's somebody new elected now, so they've changed the policy and they've started to send people. I think when the DA is involved also, they make the effort to go the extra mile to locate victims, in particular certain counties like Orange County and some other counties. I've had other DAs, like from the life crime DA, and then there'll be some secondary crimes that were committed in prison that received sentences, not necessarily life sentence, sometimes, unfortunately, depending on what happened in prison. But those DAs will come as well. And sometimes those DAs have, because they're allowed, they're invited, but the non-appearing DA like LA, they went to the efforts to get the victims there for the life crime DA that wasn't there. So, and I know victims services send out letters, but they just send out letters with address on file, and that's it. There are some of these DAs that actually make the effort to locate victims, talk to them, and about appearing at the hearing. And the statistics show that when the DA and the victim come, it drops the grant rate from down to like 50%. So whereas a suitable candidate, generally suitable, because it doesn't have to be perfect presentation, will be granted in most cases, bring the DA and the victims, and your chances go down. And that's just, I think it's the nature of, it's human nature. The DA, the commissioners, we all have codependency issues. We all suffer from those. And I think that plays a role. It's hard to grant parole in the face of 5 victims crying and the terrible crime and that sort of thing. And then the district attorney, they make their statements. A lot of them waste their closing statement on, relitigating the life crime. They spend 5 minutes talking about the nature and circumstances of life crime, and that's their right to talk about whatever it is they want. But obviously they're presenting they're trying to, it's like inflammatory rhetoric, and I'm just used to it from being a trial attorney with prosecutors for 10 years. And, it's their game. And if I was a prosecutor, I'd probably do the same thing. And I have to remind my clients, they don't represent you. So don't get offended. They represent the people. They're there to make sure, as that check and balance with the commissioners, if the commissioners miss something, and they have asked some questions during clarifying questions that have sunk a boat that was actually, floating and doing well in the hearing and sailing just fine. And all of a sudden they ask a question, the thing goes awry, the wind shifts, you're tacking the wrong way, and there's no more grant of parole, because you can kind of get a sense of whether a case is going to be a grant or a denial. Sometimes it's harder than others. I had a case last week with Tyra, who's, just call him no grant Tyra. Sorry, Mr. Tyra, but you don't grant a lot of parole. And the DA was there, not very sophisticated, asked a few questions. My client knocked it out of the park on his questions, actually used the DA's questions to kind of rehabilitate himself on some other questions that hadn't gone as well during the hearing. But in my estimation, that should have been a grant of parole. And I've gone off on a little bit of a tangent, but I'm going to do a request for decision review on that, because and it was a sex crime. Yeah. Mm-hmm. And he should have been granted, but there were victims there, and the DC, you could just tell she was biased against the case as well. Could I put my finger on something? No, it was just the tone and the manner in which how she asked the question, phrased the questioning, and you knew. And Tyra didn't ask a lot of questions about the life crime and all this. I was like, oh no, he's not getting granted. And I thought he was a great client and should have been granted. But the role of the district attorney at that hearing was interesting, though, because he asked questions that actually helped my client build his case. He'd make an even stronger case for himself. gave him an opportunity to fix a few things, and
Right.
gave me a few ideas for what to ask during clarifying, but
Mm.
no can do for that guy. So I'm stuck doing a request for decision review, which will probably be denied, but I think it's worthy of a habeas, which I thought I would run by you, Dean, later. But anyway, role of the district attorney. Joe, chime in. Let us know why you included this chapter, what it's about beyond, what I might have mentioned, and anything else you want to add. And then we'll go to Dean.
Yeah, when the district attorney is there, they're doing their job. But unfortunately, a lot of them just, like you said, want to relitigate the crime. They don't, and the hearing's not about that. It's there, but it's about the subsequent growth and maturity of the incarcerated person and what they've been doing to change their life around. So the DA comes, and the more enlightened ones, talk about the rehabilitation of the incarcerated person and asks some questions about that. And as a matter of public policy, of course, they have the right to come and be there and oppose parole. But like you said, Elizabeth, they're just, many of them are just there to kind of rehash the crime. And that really doesn't, help with whether or not they're suitable or not, because these are things that went on, 15, 20, 30 years ago. And the commissioners are looking for the change, and that's what it's about. How their insight, their remorse, what they've learned about themselves going forward, and what they've changed, what has become their new mindset. So, just as a matter of public policy, they're there, but I'm always hoping that they'll look at the efforts by the inmate to change themselves, and that it doesn't seem to happen too often.
Mm-mm.
Dean, chime in.
Yeah, it's the district attorney. So it's through reading hundreds of transcripts and a personal experience. We teach the guys to, when they go to the board hearings, how to prepare for the DAs. You don't control what the DA is going to say. You don't control what he's going to do. And from my experience and the transcripts we've read, it seems that a lot of times the DA, and he's doing his job. And that's one thing we share with the guys. Look, no matter what this guy says, he's doing his job. That's what he's supposed to do. He's going to go up there and he can call you the worst names in the world, and you're the worst human being who's ever walked the face of the earth. And that's okay. He's supposed to do that. He's doing his job. It doesn't matter if you're in there for murder or shoplifting. You're still the worst human being who's ever walked the face of the earth. So we teach the guys to just take it. Take it on the chin, show no expression, don't roll your eyes, don't furrow your brow, don't cross your arms, don't make a face, just take it. He's doing his job. So go in there with the mindset that that that's what he's going to do. And if he doesn't, then all the better, so you're winning. But just, be prepared for that to take place. A lot of times, and I agree, a lot of times, it seems that the DAs are more focused on the crime, when the crime took place, rather than the current. And I think that the commissioners definitely pick up on that. And what I've noticed is a lot of times the commissioners, they'll listen. And it shocked me the first time that I experienced and read about it, where the commissioners, they listen to the DAs, but they've heard it 1,000 times. They're not new to what the DAs are there for. And so it doesn't seem to really impact their decision. And especially if the district attorney is just pounding away on the crime when it took place and not really looking at the rehabilitative efforts that have taken place all these years later and who that person is today. So yeah, it's a matter of just, sharing with the guys that just go in there, be you, don't just take it with a grain of salt. Don't take it personal. He's doing his job. And, a lot of times it's the same way with the commissioners. The commissioners have a very tough job. They're the gatekeepers. And a lot of times they may lash out. And if they do, that's okay, because that's what they're supposed to do. So in the same note, just don't take it personal and just take it on the chin.
Love that. Yeah, 100%. And I send my clients a letter that say, just look forward, no faces, no, your best poker face through the whole thing, hopefully. And yeah, I don't know what their role is really. And one of the things they do is before the hearing in the 10-day packet, they provide their letter of opposition. Again, not the most creative either. And that's fine. They got hundreds and thousands of cases. So they take and they'll rehash the risk assessment basically. And if it's a moderate, they'll go, see, it's aggravating, because why is aggravating not a neutral, a no impact? But anyway, never mind about that. That's a different day, a different YouTube show. But also, and at the end, they'll have like one sentence, he's unsuitable because the risk assessment on this one line, like the governor does in his referrals, this,
Right.
Risk assessment says, he's got, developing insight. He's my ultra strong protector dog there. So, that's such a rehash. But one of the things I've noticed they try and do as well is they try and put reports that are not in the central file, and they can do that as long as it's 10 days before. A lot of times, depending on how well I've prepared my client, I might not object if they put stuff in there after the 10-day cutoff, because you can run the risk of not a very, I don't know, judicious, I don't know what to call it, commissioner who might say, oh, well, let's postpone then to give you time to look at that material or whatever. And you don't want that. So sometimes I just say, because what they're supposed to do is just not permit it and move forward. So they're supposed to object to it being included and strike it. But most of the time, it's some old police report, unless it's really a sticky issue in the case. It can be helpful, but a lot of times the attorney might be able to use it to argue some contradiction or whatever. Sometimes they put it in, in particular, because they have access to records that we don't. So if the guy's coming in there with a PC 5011 claim, they're going to put this thing about the crime or whatever. But if you're going to do PC 5011 anyway, a good attorney knows how to handle that. And you can comb through that record with your client anyway and find all of the things that can not be reconciled or could be reconciled with the story or whatever it is. Because it's plausibility. It's not reasonable doubt or even clear and convincing evidence, or even preponderance of the evidence. So it's really low, in my estimation. Plausibility is very low to overcome for the commissioners not to be able to rely on the denial or admission of the life crime to make a decision. So I find them doing that. They try and put the autopsy report with the photos. Those are being rejected. The photos are being rejected. And that's a two-way street, by the way. But I had a client want to submit this gruesome photo of what it would look like to be burned with a butane lighter. And it was an example because I was putting on a PC 5011 case for him, and they rejected it. And I probably should have pushed back because it was an important contradictory piece of evidence in the case. But again, most attorneys, unfortunately, still are very afraid of litigating properly and thoroughly a PC 5011 claim. And if you have a DA that did the case or did the trial or has access to all those records and then submits those, and then the attorney is not prepared to rebut that and support the PC 5011 case with a proper, argument on their behalf, then that's, unfortunate. So that's the DA's role as well. I've noticed they put like things in either inflammatory rhetoric or missing piece of the puzzle about the crime. He comes in, he said it was only 5 bullets, and then they put the autopsy in 25 bullets and they go, oh, see, minimizing. And so, but that's their job. I mean, I would do that if I was a prosecutor. So nobody mistake my tone with any type of disdain, because if the roles were reversed, I would be doing the exact same thing. And they are there to protect the public. And sometimes the commissioners get it wrong and grant parole to the wrong people. Let's face it. Don't take that the wrong way either. I mean, they're there to, as a check and balance, to make sure all questions are asked. Well, Commissioner, you didn't ask about this, this, and this. And like I said at the beginning, that can really sink the boat because the commissioner missed it. You've got somebody that we're heading toward a grant of parole that probably wouldn't have either held up or the person wouldn't have been successful on parole, because these suitability criteria, let's face it, they do have a nexus to whether somebody will be successful or not on parole in general. And I know it's a wide paintbrush of generality that it's applicable, but in general, I do find that if you have the insight and you have a good plan for how you're going to manage your stress on the outside, and what are you going to do when you lose your job, and what are you going to do when your mom dies, and what are you going to do when you run into an old gang member, and those have happened. I know, because I used to have a couple of people on the show that got granted parole, and they were ex-gang members, and they had some issues, believe it or not, even though they were 50 years old. Crazy. But the role of the district attorney, it is important. It's an important role, because otherwise, we have to have the check and balance, just like we have to have it with trials and everything else. Although it's not an adversarial process, it isn't an adversarial process. They are there to be the voice of the people. And the majority of the people don't want people released on parole. And so they are representing, in a democratic society, what the will of the people is. So let's just show some reverence to the process and say, when you get a grant of parole, it means something. It's not just M&M at Christmas time. You flip the arm down and the M&M comes out. It means something. When you get that grant of parole, it means it's powerful stuff. It means you put in the work, you figured things out, you healed from trauma, you tried to make it right, you made amends, you put the effort in. Someone said, make the effort, and you said, okay, I will relinquish my false pride and my fear, and I'll do it, and I'll become a different person. And I think it's transformational, it's redemptive, and I just think if you can overcome the DA's argument and get a grant of parole, even better. Right. So you want the district attorney to be challenging the commissioners too when there's a grant of parole. That way there's even more record in there for your attorney to use to argue, look, it was all fully tested. The DA was there. They asked all these good questions. They submitted this oppositional letter. Look at it. The oppositional letter, thank you for submitting that letter, because it showed us where potential weaknesses are, and he addressed all those at the hearing in the following manner: A, B, C, D. So everything can be used, like in the Course in Miracles says, everything's an opportunity, everything's a gift. And I would look at it that way. I really would look at it that way, instead of looking at like they're the adversary, they're the problem, they're the enemy. No, I wouldn't do that.
Right. Yeah, I agree with that. It's they have a job to do, and they're going to do it. I like what you said about the person being prepared, having the insight, the understanding, and being able to share their recovery, their transformation. And that's what it really comes down to. It doesn't matter who's in that room. The conversation is with you and the commissioners. And if you are ready and you have transformed your life and you're doing the things you're supposed to do, you can get the date. It doesn't matter what the DA has to say, because the commissioners are going to see the change in you. The DA, if he opposes, which mostly they do, okay, he's doing his job. But it's up to the individual to be prepared to be able to articulate those things to the commissioners so that it's not an issue. It doesn't matter who's in the room. And, earlier you were talking about the victims, and, the district attorneys, of course, they, send out the notices, victims come in, and you talked about the reduction in grants because of the presence of the victims. I think that even on the initial hearings, it's extremely hard to be granted a date. It is on initial to begin with, but especially when victims show up, because it's also the first time the commissioners are hearing from the victims. If they're denied, after that, the victims show up again, there's not a whole lot new that they can say. And in the same way, there's not a whole lot new that a district attorney can say. I mean, he might, try to dig around and find something, some statement that was made, but the commissioners have heard it all 1,000 times. They've been doing this a while, so they're not new to it. And I think that they take that, because I've read some victim statements where this person should never be released. They need to be locked up for the rest of their lives, this and that. Okay, but that's not the law. I understand your feelings and I can empathize for you, but that's not the law. The law doesn't say that they need to be locked up. So I think things like that, the commissioners, they disregard. They'll take it in, but they don't hold it to a high standard, especially after the first time that they've heard from the victims.
Yeah, and it's tricky. Those victims are tricky, but that's a subject for another day. The victim statements and the coming in with additional information, creative information, because I get the victim statement, and here's another thing I want to say: a well presented argument by the district attorney is going to be have much more impact on a denial or grant rather than someone coming in, and maybe there's a policy reason for it. Maybe they want to pay respect to the victims by putting it out there what happened and showing respect to what happened and doing it that way. Maybe there's a reason for that. Okay, like to acknowledge the pain, acknowledge the nature and magnitude of what happened and all of that stuff. I wonder about that. But when I've heard a really good closing argument from the DA, I'm kind of like, oh, gulp. When they can really point to the deficiencies in the insight or really make a strong argument about nexus between the year and a half ago something or other RVR of some nature and the crime, and really point to those things that are used to deny parole, which the crime is not because of In re Lawrence generally, although there's exceptions, but it cannot be the sole basis to deny parole. Then you want to be scared, especially if you also, not scared, but that's not the right word, but you know what I mean? Like, okay, we've got some issues here and we're probably looking at a denial of parole. Whereas if that DA had not come and presented that very well presented, reasoned, right, appropriate, respectful, lawful grounds for why parole should be denied, if they hadn't been there and hadn't picked up on some of the surface layer stuff that was presented, maybe would have got a grant of parole. And the other thing that I was going to mention was the well-presented argument and also lending credibility to the office itself. So when a district attorney comes in and submits appropriately, doesn't even make an argument, and that's kind of like, yeah, I don't want to say anything because I don't want to disparage victims or show the public like this office doesn't care. But when they have gone that extra mile and go, this isn't a suitable candidate for parole under the law, I don't have anything to argue. I would just like the commissioners, if you are going to grant parole, please put in place this, don't let them parole back to the counties where the victims are, and this and this. It's extremely powerful when they do that, because the next case, if they're sitting on the next case, that day or the next week or the next month, and that commissioner sees that district attorney has that type of integrity, you're again looking at, gulp. Like, I've got a DA that's a very good DA, and so I've got a very good opponent, a proper opponent here, making sure that we're releasing people that should be released. Now, my job isn't to make that determination. I'm just saying that it does make it harder for us to respond to a really well-crafted argument, because sometimes I can just sit there and they've just gone rant. The crime's awful. Yeah, it is. I agree. But rant. I don't even have to respond to anything. I can just go straight to something that I've prepared and not even deal with the district attorney. So I think that role of the district attorney should be that really high integrity district attorney, deputy district attorney role, rather than this Orange County Sacramento, Riverside, that just doesn't matter who you are, you're unsuitable for your entire life until you die. So that's just my little rant. But again, everybody's got a different style. Everybody's got a different path. It doesn't matter that I like them or I don't like them. I don't dislike them. I don't have any animosity toward any of them or the style that they pick. I'm just saying what's the more effective style for them and what makes it more difficult for us. And that is the ones with more integrity about really picking and choosing. You don't have to throw everybody a bone, but sometimes it's just really obvious. And then when you have a DA going, he's unsuitable, I'm like, this guy could come and live with me. Like, he's that suitable, and they say, and then everyone's just looking and it just loses so much credibility. And it's just like us arguing for he's suitable, please grant him parole in the face of a man or woman who looks clearly like a 7-year denial. Again, we lose credibility, but that's another chapter of Joe's book. Right. Joe, anything to jump in on?
No, you guys are great. The DA, they can, like you said, I think they have credibility too, or they don't have credibility. Like last week, there was a DA from, I believe it was San Diego County, and she was trying to say that there's all kinds of self-help now in CDCR, and this person hasn't taken advantage of it, but he was a sex offender, and I used like maybe 2 seconds just to, rebut that, because there are no groups in there. And that's why we have things like with Dean, Lighthouse 9, to help those types of crimes. And, she wanted to argue that, he's been down 15 years, hasn't done anything in that area, but he did have Road to Freedom, and I think he was in Sex Addicts Anonymous as well. At Avenal, doing what little they have over there, trying their best to be sincere and really work hard on changing themselves. So, with anything, it's a mixed bag. There's some, attorneys from the district attorney's office who get it, and there's some that really don't and just want to focus on all the negativity surrounding the commitment offense.
Mm-hmm. God, that leads off into a whole nother discussion too. That's probably another chapter for another day. They're just, I think that some district attorneys, they're, I don't know if they're aware or not of what is available, what's not available within the prison system. Mm-hmm. But I think that some of them will definitely use that as, their way out. He hasn't done enough programs. Well, you have one prison that runs a legitimate program that's offered through the state. That's it. And they only take about 70 people a year. Lifers are not included. They're more of the short-termers. What are you supposed to do? So it's that's a handful.
Yeah, the programming, Avenal has quite a few, and the chaplains will run a bunch of stuff out of certain yards. But again, point to the evidence, prosecutor, point to the evidence, because only evidence can be used to make findings and decisions. So that's, one of the ways we can do it as well to counteract their comments. But again, just, I'd like to conclude just with, I started my career in criminal defense and being with a lot of animus and oppositional attitudes toward the prosecutor, because I felt like that was my duty of loyalty to the client. And now I just think that compassion for everybody and the role we're playing is probably a better approach. And I still can have a lot of loyalty to my client in having compassion for a commissioner who doesn't get it, or a DC who inappropriately asks questions about the victim's boobs or whatever it is, and just having compassion, because Lord knows I am not perfect. I screw up. I'm not always the most artful. And, as a DA, who knows what I would do? And just to see them as my brother or sister in Christ is in Christ consciousness or whatever floats everybody's boat, I think is the most important thing. And that gets back to Dean's comment at the beginning, is have your loved ones approach the DAs in the same manner, because ultimately, even if they do say something offensive or horrible or mean, most of our clients have done some irreparable damage to someone's family member or the victim. And so what right do we really have, because I'm the agent of the client, to really bark and complain about the DA if they've been, they hurt our feelings in some way? And just like you said, Dean, let it go. It doesn't matter. It's up for the commissioners to give it whatever weight they think it deserves. And even then, it's a closing argument. It doesn't even get weight because it's not evidence. So, and that is to be remembered. The case law is very clear. The closing argument of the DA, not evidence, not evidence. And also, if they try and introduce evidence, which they do sometimes try and introduce some evidence during the clarifying questions or the closing statement. And that's just, that's why we're the attorneys and we just stay on guard. And that's why it's like a contest in a way sometimes, even though it's not adversarial. Just make sure that you're on your toes and you call them out. And we make mistakes as well. So I think we'll end on compassion if everybody's happy with that. Unless anybody has a burning desire to add to the mix.
I'm good.
Yeah.
We loved having you, Dean. Love. We're hoping Dean will be a regular fixture for us, because he just has some extremely valuable insight.
Absolutely.
And I know Joe's working on a 3rd edition, and so he's taking all of this in, and eventually he's going to integrate it into his 3rd edition.
Elizabeth,
yeah.
I'm not writing a 3rd edition. I'm writing a brand new book.
Oh, it's a brand new book. Okay.
Yeah. All right.
Thank you.
I could do a 3rd edition.
You were going to do a 3rd edition and a brand new book, but okay.
Yeah, so not necessarily in that order.
Yeah. What's the brand new book going to be?
It's going to be more about, like, from the point of view of actually going to the hearing and what happens in the hearing and preparing for that.
Okay.
Because I view 36 strategies as kind of all the fundamental things. And so this is going like a little bit beyond the fundamental things, like, comprehensive risk assessment, for example, and being more like nuts and bolts of what to actually, do and prepare for it in the hearing.
Okay.
Because they're always so nervous. So these are things like tools they can use in the hearing, reduce stress, to anticipate questions, just everything, kind of what the process is about, and hopefully cover things that I didn't cover in the 36 strategies.
Okay, so if you decide to revise your second 36 strategies or write a third, I love having my brain picked. So there's it's just I think from our perspective, having sat in that seat, there's things that we see that I think that bring value that an attorney may not notice because you've never been in the seat, fortunately, so it's this is a lot of the stuff that I teach with the guys that we work with, and it opens their eyes to a different way of thinking. And so, if I'm always available and would love to help out.
Great. Thank you. Mm-hmm.
Yeah. Writing a book. Wow. You guys are awesome. Enjoy your Mother's Day. For those of you who are mothers, maybe you have pets, maybe you have kids, doesn't matter. And I will see you next Sunday. Oh, tell us the topic, Joe.
I haven't even looked that far ahead.
Okay. We'll see it on the post then. Never mind.
All right. Okay.
It's probably the victims, maybe. I don't know. Yeah. Okay. Thanks,
All right,
Joe.
real good.
Thanks, Dean.
Thank you.
Have a good weekend.
Okay.
Bye bye.
You
Bye.
too. Okay. Okay. Bye.